AI companies and fledgling startups will have trouble complying with state laws and will be put to a disadvantage and then wither on the vine.
States have filled the gap that this Congress, which did not regulate the internet, did not regulate privacy generally, have done so. And I think with AI technologies, if Congress is for whatever reason not able to pass comprehensive legislation protecting Americans, states will continue to fill that gap as they have in the internet age.
So the notion that this is the right body to regulate the most powerful technology in human history, whose workings are actually largely beyond the understanding even of the technology's creators, is a fairly fantastical notion.
For generative AI, it's not about creating speed and safety laws and building highway guardrails, but rather building a road system in the first place. Some of my colleagues would argue that the construction of local roads is unnecessary. They say that without broad preemption, without clearing the field of all state-based legal encumbrances, AI companies and fledgling startups will have trouble complying with state laws and will be put to a disadvantage and then wither on the vine. I've heard little to suggest that broad preemption is in fact the appropriate solution to this problem. Proponents of preemption present Americans with a series of false choices, telling us we must choose a side between AI innovation or state powers and federalism, between business and consumers, or national security and safe innovation. In 1816, Jefferson wrote, "Laws and institutions must go hand in hand with the progress of the human mind. As that becomes more developed, more enlightened, as new discoveries are made, new truths discovered, and manners and opinions change, with the change of circumstances, institutions must advance also to keep pace with the times." What we're seeing across America is individual states looking at these amazing technological developments and asking whether and how their laws need to change to protect their citizens and advance the common good.
The purpose of the IP clause is not the profit of creators, it is the progress of society. And so what we need to get back to are those first principles when it comes to examining copyright law and patent law. Right now, if you look at analysis from scholars such as Richard Watt, you will see that the preponderance of copyright benefits are not going to your average Joe and Jane author, but to large publishers. And so we need more analysis on that front.
Would you agree that ensuring transparency in AI systems, such as being able to trace what data was used to train a model, is essential both for protecting IP rights and for maintaining public trust in AI platforms?
I would agree that broad overviews of the sources of training data are important to get an understanding of where and how models are being trained.
And in that same spirit, could giving creators a private right of action for tampering with content credentials help strike the right balance between protection and innovation?
My own estimation is that granting that sort of right would be a significant barrier to AI innovation, given the centrality of access to data for innovation. We've seen that many courts and many scholars have regarded the use of data as a transformative purpose under copyright law, and denying the ability to train on wide swaths of data would be a real hindrance to our ability to leverage AI. As many folks have said on many occasions, bad data leads to bad AI. If you want better AI, you want better quality information. And if we throw many legal gears into that equation, we won't get the AI we deserve.
Thank you. Dr. Bray, as we consider whether and how best to regulate AI platforms, do you believe that we must avoid the same mistakes we made in the early days of the internet with broad safe harbors that gave platforms a free pass for enabling copyright infringement and countless other harms?
Thank you for that question, Representative Klein, and as a fellow Virginian, glad to be here. So I was around actually working in the 90s on the early days of the World Wide Web, and my observations would be we did fit for purpose for the 90s. Now, in the 2 decades since, we have seen the rise of applications on top of that technology where we may need to make adjustments. And I think what we need to separate is the desire to roll out the technology so that the entire nation could have access to the internet. And at the same time, if we see that the applications need adjustments for the law, that would make more sense to adjust. However, I would say what we need to recognize as well as we go forward here, where are we trying to advance the technology so it can be used by startups, it can be used by communities, it can be used by legacy organizations that haven't gone AI native yet. And at the same time, if we see there are applications where we want to prevent harm to individuals, to children, or things like that, adjust the applications while not limiting innovation on the technology.
Just like other businesses, bad actors have to be accountable for the harms they cause. In addition, if we consider some type of temporary pause for state-level AI-specific regulation, we have to ensure that other generally applicable state and federal laws continue to apply, with copyright law being one example. Do you think AI platforms should be held to the same standard of accountability as any other business, including when it comes to respecting copyright?
Absolutely, and I would actually say that's why I'm so excited about federated learning, because there actually could be the opportunity where, whether you're a recording artist, you're a musician, you're an individual, you could actually say, here's the data that I have pooled, you can learn on my data in situ as opposed to shipping it somewhere, and we can have that actually recorded as a transaction. And then in return, I'm getting benefit, whether it be financial or otherwise. It's a new model that's actually quite possible. It's been possible for more than 5 or 6 years, and we can motivate people to do it.
Thank you very much for the question, Representative. Always good to talk to a fellow Texan. Hook 'em. So I think in any prior study we've seen of the impact of a rush to regulate among states, there is a real noticeable impact on small businesses. If we look to research, for example, from INGEN, done in conjunction with the Michigan Ford Public Policy School, we see that just changing a privacy policy statement may be $6,000 in funds to outside counsel. That's $6,000 out of $55,000 of monthly revenue and operational expenses. So from a small business perspective, the rush to regulate is a real hindrance on innovation. I also think that the rush to regulate among the states creates a patchwork and a huge risk of extraterritoriality in terms of application. We've talked a lot about Virginia today, which is welcome. At the time of the founding, Virginia had around 700,000 residents. Delaware and Rhode Island, something around 30,000. The founders didn't say there was a Virginia privilege or we should have a Virginia effect. They did not want to see that happen. Instead, they made sure that states stayed in their respective borders when it came to regulation.
Thank you. And is it possible, do you think, for bad actors to misuse inconsistencies, especially in terms of violating intellectual property rights?
I think that we've seen a documented effect of what's referred to as regulatory overload, as folks at the Mercatus Center have written about. When we have endless litigation, endless labels, endless warnings, actually what we get is less safety because people don't know what law to adhere to. If you talk to a lot of startups today, they don't have a public policy person. They don't have a general counsel. So just adding more laws to the equation actually reduces the odds of user safety.
Thank you. I appreciate that. I yield the balance of my time to Mr. Correa from California.
Thank you, Mr. Gooden. Gentlemen, listening to your debate today reminds me of what General Patton used to say, which is lead, follow, or get out of the way. AI is moving faster than we imagined or we even expected just last year, touching every aspect of our lives. Most of our constituents, like many of us here, don't know a lot about it, but they know enough to expect that we here will protect them, their jobs, their children, their intellectual property. And so the debate about whether it's local control or federal control, I think is second to the fact that we just can't move on this stuff at the federal level. And so, Mr. Frazier, you're from Texas, I'm from California, fourth largest economy in the world. But how do you coordinate federal and state action to make sure that we respond to our constituents responsibly? Thank you.
Thank you for the question. And I was a Berkeley law grad, so I share some California ties. I want to emphasize that we do need to see regulation in this space, and we need to see that Americans are protected, and especially our vulnerable communities and children. What I'm concerned about are laws like AB 1046 out of California, for example, that imposes on AI companions a desire to prioritize factual accuracy over a user's preferences.
1047 or 1046?
AB 1046.
Okay.
Prioritizing factual accuracies over the preferences of the user, in this case, a child. To which I ask, who gets to define factual accuracy? Is it California state government? Who's going to answer the question of, is Santa real for a 7-year-old? Who's going to make factual determinations about religion for that child user? Those questions shouldn't be answered by California for the rest of the country.
I would ask you to also look at SB 53 that's now being addressed in the California state legislature and see what you opine on that as well.
I think SB 53 is the least bad option I've seen with respect to AI development regulation, as we've discussed in this hearing. AI development, in my opinion, and in the opinion of many, should be left to the national government as a core.
Anything you agree with in SB 53?
I very much agree with the whistleblower protections. I think that's an important mark. I also agree with the fact that it calls on regulators to revisit definitions and terms frequently to make sure they're working as intended.
When we're talking about a subject that affects the economic or political stability of the United States, and you drew a distinction between pigsties and artificial intelligence, would you elaborate for us, please, about why you believe the things that we're discussing here today do go to the heart of the economic and political stability of the United States and should be distinct from those areas where the laboratories of democracy concept actually works?
Thank you for the question, Representative Lee. I think it's profoundly important to get back to that Brandeis quote about laboratories of democracy. There's a forgotten portion of that quote, which is without risk to the nation. You can run an experiment without risk to the nation. Many of these experiments that we're seeing proposed and enacted in California do pose a risk to the nation because they try to impede AI innovation itself. When we see individual states reach into the AI development process, they're not just tinkering with a modular process. There is not a AI-specific training run for California that OpenAI does. Anthropic doesn't train its models 50 times over for each state. So while there may be a lane for state regulation, and I believe there's a lane for state regulation with respect to AI use, we have to follow up and ask the question of what does a real experiment look like? And that experiment can't be one that exceeds the borders of that state. And yet California's bills, time and time again, would result in labs having to change their practices the nation over. And I've lived in California, I've lived in Florida, I've lived in Texas, I've lived in Oregon, I've lived in Massachusetts and in DC. And I can tell you in each of those places, they don't want Californians dictating the terms of their AI.